So we're talking about an interesting topic, which is who can be on the deed. So anybody can go on the deed as long as you acknowledge the mortgage if you are getting a loan. But you also have to be on the real estate contract to be on the deed, because remember, the title company that's closing your transaction follows the contract. So they can't add you to the deed if it's not on the contract. That would be a violation of what we do. So you have to addend the contract, which all parties would agree to. The seller doesn't care that the buyer's adding somebody. That wouldn't matter to them at all. So just addend the contract, but make sure that you allow plenty of time, because a lender might say, you didn't give us enough time. We have to review that with underwriting. So you want to do it at least 2 days in advance of closing, but better for 3 days, if not more, before the closing. So if you're not married, how do you take title of the property? You can't take it tenancy by the entireties, because that's for married people, right? So you take it tenancy in common, or tenancy in common with right of survivorship. Once again, consult with an attorney. But the idea behind both of these tenancies is that there's separate interests in the property by 2 or more people. Now, if you were married and you held your property tenancy by the entireties and you got divorced, very important note that upon being divorced, your property immediately turns in tenancy in common, which means the debts and liabilities of the other can attach to that property. So that's a nuance of getting divorced that you must pay attention to. Once again, consult with an attorney. Some owners, married couples, might want to take a deed in their name and not in their spouse's name, right? Well, you can do that. Nothing wrong with doing that. But just so you know, Florida has some of the most protective laws to protect the surviving spouse. One's called the Florida Elective Share, and the other one's the Florida Homestead Act. These 2 acts are very important to protect the surviving spouse should somebody die intestate, without a will, or with a will, and they try to transfer their property to somebody other than their spouse. So can anybody be added to the deed after a closing? Well, if it's a free and clear property without a lender, then of course you could add anybody you want. But remember that once you add them, you might not be able to take them off. You might need an attorney to do that. You might not even be able to. And if you have a loan, adding a person to the deed without notifying the lender would, on its face, trigger a due on sale clause in the note, which could cause the lender to call the note, right? So before you add somebody to the deed, I would consult with an asset protection attorney or a probate will attorney to make sure that you've been given proper guidance on that topic. Hiring a real estate lawyer might be uncomfortable with some people because, they're going to want a retainer or some things like that. But when it comes down to big assets like deeds and transferring deeds and adding people to deeds, you should consult with an attorney, because if you add somebody to a deed, maybe that new ownership has triggered some things in your life that you're not aware of. Like Medicaid has a limit to how much you can make or how much you can own in certain limits, right? That's one. And also there's a gift tax liability where if you own more than a certain amount of this new asset, you're going to owe money to the IRS in the form of a gift tax. So Florida is a separate liability and a separate property state. That is the concept that we use in the state of Florida to enter into tenancies by the entireties for married couples, which basically states that the debts of one spouse do not affect the asset of the other, because they have the right to enter into debt arrangements individually and together in the case of a mortgage. But individually, those liabilities do not attach to one another. That's the concept in the state of Florida. But one nuance to that, once again, is the IRS. IRS debts for either spouse do attach mutually. I try to bring simplicity to this industry because it often is so complex that a lot of people pay no attention to the details of title insurance. But thank you for listening to my video series on title insurance. If you find it useful, please share my videos with a friend or subscribe to my channel. Thank you very much for listening.